Welcome to NatSec MTech, a podcast designed to push the boundaries of national security and emerging technologies. I am your host, Laura Donohue, professor of law at Georgetown and the director of the Center for National Security. Join me here as we explore the world of AI, VR, space, cryptocurrencies, biomanipulation, and more, all with the goal of building a safer, smarter, and stronger future. Let's dive in. Joining me today is Todd Pennington, who is a senior research fellow at National Defense University, as well as an adjunct professor of law here at Georgetown Law. Todd, welcome to Space Law 201.
Glad to be here.
So we have the placement of objects in near-Earth orbit, but we also have probes that are going out beyond the solar system, looking at other systems as well. What are the principles, and do these principles apply to all of those elements of space? Or are they only applicable in certain parts or aspects of space?
Well, under the Outer Space Treaty framework, for most purposes, if it's beyond the Earth's atmosphere, there's not a definition of where airspace ends and outer space begins. That's called the demarcation problem. Airplanes can only fly so high before they just don't work as airplanes anymore, and satellites can only orbit so low before they grabbed by the atmosphere. In between is a zone. The boundary between airspace and outer space is somewhere in that zone, and rockets transit through that zone on the way to space. But once you are in outer space, the Outer Space Treaty framework treats outer space as a unitary jurisdiction for most purposes. So the principle of free access is captured in Article 1 of the Outer Space Treaty, which is the idea that all states have right to the exploration and use of outer space. It's not limited to exclusively peaceful purposes, the way that use of Antarctica is, or the way that use of the moon is. But it's an acknowledged interest, but it's not a constraining, limitation. There is the principle of non-appropriation, this idea that states may not appropriate areas of space by means of a claim of sovereignty, by means of use or occupation, or by any other means. So sometimes there's a flavor of sovereignty in the continuing jurisdiction and control of space objects. But there's this idea of non-appropriation. If you imagine a future where there is a broader use of the moon by more states on a more enduring basis, at what point does this principle of free access butt into the principle of non-appropriation? I think the example of Antarctica, again, is helpful because we've had that same construct in Antarctica since 1959, and even though it's much easier to get there than it is to get to the moon, those principles have not come into unmanageable tension. Another principle that matters a lot that international law applies. That's Article 3 of the Outer Space Treaty, and it's an acknowledgement that every question of how states deal with each other can't be answered by an outer space specific legal framework. There can still be just state-to-state considerations, and all those concepts of international law are still applicable in space because they apply as between the political entities that comprise the UN member states. And so those political entities take their political affiliation into space and engage with each other on those same terms, pursuant to the principle that international law applies.
So ostensibly that includes things like Article 51, the right of self-defense, the law of armed conflict. So if we're talking about actions in space that might involve conflict or war, then you would assume that LOAC actually applies also to space.
Well, that's the U.S. position about the article. China and Russia have expressed concerns about applying the law of armed conflict in outer space. I think the generally permissive rule that if it's not prohibited, it's probably permitted.
What about weapons of mass destruction?
Yeah, so military activity generally is governed by the Outer Space Treaty. So the military use limitations that we see in Article 4, the first is a prohibition on the placement or the stationing of nuclear weapons or other weapons of mass destruction in outer space or on celestial bodies. It's noteworthy that the treaty says nuclear weapons or other weapons of mass destruction. That's not defined. Weapons of mass destruction is not usually defined in treaty agreements, but some things are intuitively that. And then there is a further limitation on the building of fortifications, the conduct of military maneuvers, the placement, testing of weapons of any kind, or stationing of weapons of any kind on the moon or other celestial bodies. Basically, it's a reservation of the use and exploration of the moon for exclusively peaceful purposes.
So nuclear devices can fly through space, but they can't be based in space.
Correct. And that's the legal authority for a capability like intercontinental ballistic missiles. They transit through space, but they don't remain in space. These weapon systems called FOBs are of such great concern. That's a fractional orbital bombardment system. And if it was nuclear or WMD, which it might be just by virtue of the degree of force that could be brought to bear from a weapon discharged at that altitude, it would be in violation of Article 4. But a fractional orbital bombardment system enters a partial orbit and then can re-enter, unlike a ballistic missile that's basically thrown and its movement carries it through space, but then gravity brings it back down to Earth to its intended target.
Could that fraction be 90% in orbit and 10% or 0.0001%
It could be any percent, and they're very concerning because they can approach from azimuths that missile warning systems are not optimized for, and they're hard to track, they're hard to detect, and that makes them destabilizing because they evade the traditional missile warning systems that provide that advanced warning and brings a measure of stability to each side's nuclear deterrent.
So fractional orbital systems seem problematic. What about hypersonic?
Well, hypersonics don't necessarily have a distinct legal status under the Outer Space Treaty framework, but certainly hypersonic is 5 or more times the speed of sound, so they certainly are much harder to detect, harder to track, harder to intercept. Hypersonics can enter space or they can stay terrestrial, so they're a challenge in a lot of ways.
What's the relationship between the New START treaty and this prohibition on WMD, and what happens after 2026 when New START goes away? That's our current only bilateral treaty with Russia regarding nuclear devices.
Yeah, so let me unpack a couple things about New START. It establishes core limits on the total number of warheads, type of launchers, and delivery vehicles it can have. It also includes the latest commitment in a bilateral arms control treaty to not interfere with the national technical means of the other side. So national technical means is commonly used to refer to overhead Earth observation satellites that look down and count missile silos and count launchers and confirm that the other side is adhering to their agreed core limits. So New START has technically expired. Russia and the US had agreed over a series of different extensions. Recently, Russia announced they were suspending their participation in the New START. They have said they would continue to adhere to the core limits of the treaty. There will be no applicable core limits if New START were to expire. Now, as to space, the biggest implications, I think, are, one, that provision to not interfere with the other side's NTM. That may still hold as a norm of responsible behavior in space and as a stability mechanism. And then there's the question of how do you count a nuclear weapon? There's reports that the U.S. officials have acknowledged that Russia has a program to put in space a nuclear weapon designed as an anti-satellite device, which would cause a number of problems for the domain and for the space systems of every state that operates there.
How do you decide what counts as a weapon of mass destruction? So one can imagine electromagnetic pulse weaponry mounted on a satellite that could wipe out some critical infrastructure with devastating effects as a terrestrial matter could equally be considered, as could the kinetic use of a satellite to take down other satellite weapons in space that are not necessarily nuclear, biological, radiological, or chemical weapons, which is the traditional understanding of WMD. How is that determined?
It's not defined. It's not defined in a lot of treaties, to the point where Institute for National Strategic Studies, where I work, actually has a center called the Center for Study of Weapons of Mass Destruction. There's different approaches to it. You could look at how much damage does it cause in terms of human life or in terms of property. You can look at it in terms of, here are the things that are clearly understood to be weapons of mass destruction. That would include things like a nuclear weapon, a chemical weapon, or a biological weapon, because those things cannot easily be controlled once they're released. But there's not a available definition I can point to, I'm afraid.
All right, so we have freedom of use and exploration, not appropriation. International law applies. No weapons of mass destruction. We've already talked through what might be a fifth principle, which deals with astronauts or envoys of mankind. Specifically, if an astronaut is in distress, comes to be in the territory of another state besides the state that launches it, they're to be returned to the launching state. The international responsibility aspect of this would be a sixth principle.
Let's talk about international responsibility because there's actually an interesting origin story to that. The Outer Space Treaty reflects the realpolitik compromises of Cold War stability. The Soviet position on access to space was they wanted space to be limited only to state actors. The US and some other states foresaw a future where commercial actors, non-state actors might be able to get to space and could be useful operators there. And the compromise that we see in the treaty is Article 6, which provides that states are internationally responsible for their national activities in space, whether those activities are undertaken by the state or by a non-state actor.
That's super interesting. Let's look at some of the other principles here. For instance, liability depends upon location. The definition of a launching state has 4 potential components. First, who launches it? Second, from whom do you procure the launch? Third, from which territory is it actually launched? And fourth, who owns the facility that launches the object? Right? So there are 2 regimes that apply here, either absolute or fault-based liability. The principle laid out in international law is if an object launched by a state in space damages another object in space, liability is based on who's at fault. But the liability is absolute if the damage has occurred on the Earth and not in space. In other words, if it happens on Earth, you break it, you buy it. You have complete liability. But in outer space, you turn and you look at who is actually at fault for the collision or the damage that occurred. Is there anything that you would add to that principle?
Well, the standards are actually found in the Liability Convention. States have strong incentives to know who is the launching state. So they pretty good about working that out in advance because no one wants to push launch on the rocket until everyone is sure and the paperwork is done. This idea of fault-based liability on orbit could be very challenging. One of the challenges in space is the growing problem of orbital debris. There's derelict rocket bodies, there's derelict satellites, there's debris from prior anti-satellite, and there's debris from prior collisions when derelict satellites just hit each other because they weren't maneuverable. And so if that debris hits a satellite today and destroys it, one, can we even tell whose debris that was? And if we can attribute it, but there's no precedent to point to, I think it's going to be an interesting question. It's a scenario I like to run when I talk to students. It's a great scenario that raises different possible approaches to how you assess fault in the space domain.
So space debris also gets at another principle, which is this enduring jurisdiction and control. International law says that a state retains legal authority and responsibility over its space objects and personnel, no matter where they are in outer space. So once you launch it, nobody else can retrieve it, meaning space debris companies cannot go up and just clear out space for derelict equipment. Could you talk a little bit about that principle, how that came about, and what the legal status is of that?
Yeah, well, every state's space systems is usually some of their most sensitive technologies. A lot of times it involves sensitive capabilities about intelligence gathering satellites. And, this Article 8 of the Outer Space Treaty reflects that agreement that, you don't get to abandon your satellite and you don't get to say okay, its service life is over, now I can go and just grab it. This would mean that a debris mitigation company couldn't go to space and grab some derelict satellite or a derelict rocket body or even a piece of debris, at least not without the consent of the responsible state. Now, certainly consenting space activity becomes an authorized space activity. No one's demonstrated the capability to remove non-consenting, non-maneuverable debris yet. Companies are working on it. States are working on it. That technology will mature at some point. But then you're left with what about objects that may be attributable to a state that for whatever reason will not consent to its removal? There's no principle of clearance, a right to remove derelict objects. There's no principle of salvage, hey, instead of re-entering this rocket body and adding to pollution in the atmosphere, we want to grab it and melt it down and use it in space for new space manufacturing. There's companies that are working on technologies like that. They could do that with consenting debris, but not with non-consenting debris.
Great. And what about this principle of due regard? To me, is one of the most woolly concepts in international space law.
So this idea that when you're acting beyond your sovereign territory, a responsible state should act with due regard for the corresponding interest of other states in that domain. That's captured in Article 9 of the Outer Space Treaty. There is also a consultation mechanism, and a state that is concerned that another state is going to do something that may interfere with their activities can request consultation. Now, interestingly, this consultation mechanism has never been invoked. There's been notices made about different activities, but they've always taken pains to avoid triggering the consultation mechanism, which I think is very, very interesting, that we have made notifications. For example, before we conducted an anti-satellite weapon test in 1985, we provided notice, hey, all you states, you may be interested. We're doing this, here's why we're doing it, here's roughly when we're going to do it, it's going to be happening here. There wasn't the risk of error or miscalculation. Is this an attack? Is this a missile launch? So it just wasn't done through the Article 9 consultation mechanism.
Yeah, well, notice is not the same as consultation.
Right.
We're doing X is not really a consultative process. So
it was a one-way letter.
Well, and what's interesting is it's also a notice about the potential effects on Earth of something that is happening, as opposed to the consultative mechanism in the Outer Space Treaty, which has to do with if there's reason to believe that an activity or an experiment would cause potential harmful interference in the activities of other states' party in the peaceful exploration and use of outer space. So it's tied to Article 1 of the Outer Space Treaty. So if you're going to do something that might have implications for Article 1, you shall consult. That's interesting because potentially everything you do in outer space may have implications, and this process has never been used. On the other hand, if you're worried about something, you have the option to raise it, assuming you know about it. But that is actually tied to harmful interference as well in Article 1. None of it has to do with the harmful impact on Earth of what you do in outer space.
People have views about why states have been so reluctant to invoke this, but China wanted to make an engagement about, they were unhappy with Starlink's degree of approach towards its Tiangong space station. But they didn't request Article 9 consultation about it. They basically sent a notice to the Secretary General under Article 5. Another of the provisions of Article 5 calls for states to make notice to the Secretary General if they discover phenomena that may be dangerous to astronauts. I think the idea was alien viruses or something like that we don't know what we might find once we get there. China provided a notice basically like, hey, we have discovered Starlink in orbit in a trajectory that we think is not safe with respect to our space station. There's different views as to how much of a risk that really was, but they provided that under Article 5, not Article 9. They didn't request consultation. They basically provided it as a notice.
Just an announcement.
An announcement.
A proclamation. Here's what's happening.
Exactly.
So the final principle to bring out here is international cooperation and reciprocity, which are in the Outer Space Treaty in Articles 10, 11, and 12. All three of those tend to deal with this idea. Specifically, Article 10 states that states should consider inviting other states to observe their space launches. Article 11 states that the state must inform the United Nations and the public about the nature, conduct, and results of their space activities. And finally, Article 12 states that all stations, installations, and vehicles on celestial bodies must be open to representatives of other states based on reciprocity. Can you talk a little bit about that principle?
Yeah, so some of these are somewhat aspirational. This idea that if there's disputes among states, they should consult and work it out. And consult not in the Article 9 sense, but basically you kids work it out. Don't come to the UN for everything. There is an interesting provision at Article 10 about a request. States will, on a basis of equality, consider requests from other states to observe the flight of space objects launched from other states. So does that mean launches? How do you observe a satellite in transit? The meaning of that's not entirely clear to me. Implies a form of reciprocity. There's a more specific form of reciprocity at Article 12, I believe it is, about stations on the moon that states will consider on a basis of reciprocity visits from other states to installations on the moon. Again, there's no state practice on this because our facilities or installations on the moon. I think some differing views about the meaning of that.
What about the international regulatory regimes? How do we think about international structures and bodies, and what do those look like?
Well, there's certainly the Outer Space Treaty framework that we talked about before. That's not a very heavy hand of regulation. There's regulatory aspects to it, most notably the spectrum deconfliction and the geostationary Earth orbit slot management that the ITU, the International Telecommunications Union, regulates. The International Telecommunications Union Constitution and the treaty that underwrites that excludes from its operation military station. ICAO, the Chicago Convention, only covers civil aviation. It provides that state aircraft should operate with due regard for the interest of other aircraft, and a similar due regard idea applies to military stations. But honestly, the ITU spectrum deconfliction function and the UN Office of Outer Space Affairs registration function is the principal expressions of that.
Let's discuss India. India is taking a leading role now. Mm-hmm. They also are planning to go to the moon. Like, what role would India play? What role China? What roles Russia? How should we be brokering an agreement amongst the countries that are pretty far ahead in terms of the space race?
It's tough to know what that agreement might be. You think about the kind of agreements or the kind of actions that have been proposed. For example, in the wake of the report of a Russian program to develop an on-orbit nuclear anti-satellite capability, the U.S. and Japan co-sponsored a resolution at the UN Security Council to reaffirm the obligations of Article 4. You can't have that kind of satellite, which, by the way, Russia denies. All that to say, even the restatement of existing obligations is politically controversial now. And in this, looking at the sort of constellation of existing agreements, most of them have one thing in common with respect to China, and that is they were negotiated before the seat at the China seat at the UN was held by Beijing. So the Outer Space Treaty was negotiated at a time when, the Chinese representation at the UN signing and ratifying the original enactment of the treaty was the government on Taiwan. So the government in Beijing may have a different view, and I think certainly they would insist on having a role in any new future things, whereas the Outer Space Treaty and its implementing frameworks fairly reflect a position of, a compromise between blocs aligned around the U.S. and the Soviet Union. That's more complicated today, where you have the largest spacefaring actors being the U.S. and China and Russia, with all these new emerging actors, India, Japan. The European Space Agency is becoming much more capable as kind of a multinational organization, and many of the European states becoming more capable as individual space actors.
What is the biggest legal challenge facing space law today?
I think there's a couple. The first is orbital debris. It is going to raise issues about liability, about due regard, about debris mitigation. All the operational realities of an increasingly polluted space environment are going to force actions that have legal implications. That's complicated because, the same technologies that are useful for debris mitigation are useful for counter space applications. But when technology advances to the point that spacefaring actors can get to the moon on a recurring basis at a degree of scale where they can utilize lunar resources, I think that's going to present new issues of space law. We'll have new state practice. It's tough to know what that might look like. It is expected that many of the resources of the moon are concentrated at the poles. And certainly at the poles is where you have craters that sit in eternal darkness, and so there's expected to be concentrations of water ice there that are useful for a lot of applications. And it's where you have peaks of eternal light, where a thing sitting there throughout the moon's orbit of the Earth has sunlight. And so for power generation, and they never sit in lunar night, which is challenging for space objects. There's only a few peaks of eternal light that will make them very key terrain. And so I think the prospect of them becoming contested will raise issues as to free access and non-appropriation fairly quickly once we can get there.
What are you most afraid about when you look at the future of outer space, U.S. national security, and certainly where the legal structures are in terms of today's environment and in the near future?
Well, going back to orbital debris keeps me up at night because it is a wicked problem that's getting worse before it can get better. We're launching more and more because launch gets cheaper as payloads get smaller. We're still stuck with the debris that's there that has the potential to raise a lot of legal issues. It could raise issues about attribution. If some sensitive satellite of some state goes dead and it's not clear why, that has the potential to really be a problem. Will a state perceive that as an attack? Will they be able to tell why the satellite died? They're hard to see. It's hard to tell why things happen. Was it a natural failure? Was it impact from a naturally occurring object? Just some rock passing through space that hit it? Or was it attacked by an adversary system? Those kind of concerns can breed miscalculation that can lead to conflict, which is why I worry about orbital debris.
Thank you so much for joining us for today's podcast. It's been a pleasure to have you on, and I look forward to welcoming you back again soon. Thank you.
Thanks so much, Laura.
If you enjoyed today's episode, please subscribe to our channel and invite anyone who would like to join us. I will see you in the next episode. Until then, stay curious, stay informed, and keep asking the big questions.